Okay, we should be live.
All right, good morning. We're going to convene the public hearing of the Committee on Veterans Affairs. So good morning and welcome to everybody. I appreciate everybody ready to go for 9 o'clock hearings, kick off the legislative day. Before we begin, I want to just yield to my co-chair, Senator Cabrera, if he has any comments. Senator.
Good morning, Representative. Good morning, everyone. Thank you all for participating today. Looking forward to a good hearing and to learning quite a bit about the various bills we're considering. So thanks again, sir.
Thank you, Senator. And just for the committee's edification, we've split these up into manageable chunks. You've probably noticed that we haven't gone for the all-day marathon on like some committees do and just have one public hearing. We've broken them down into three and possibly a fourth chunk, but we may have gone through it this go round. So there is a little bit of a method to our approach here. So starting off, to welcome back to the committee, which has become a weekly occurrence. So we appreciate the commissioner joining us. So Mr. Sadi, the floor is yours, sir. Oh, you are muted, sir.
Of course, at least I didn't go on for a few minutes. Senator Cabrera, Representative Boyd, honorable members of the committee, thank you very much. And because you break this up into smaller chunks that are more digestible, I had the opportunity now to see you for the third time, which is actually nice. I do enjoy hearing before the committee. Thank you for the opportunity to address you today on several bills and for your continued service to our state and in particular to our veterans. My testimony will focus on three raised bills, which I believe had the potential to expand in certain ways veterans recognition with generally a fairly minimal fiscal impact. I am proud with regard to Senate Bill 914, an act concerning the Hmong Laotian Special Guerrilla Units served in the Kingdom of Laos. I'm proud that in 2019, the Connecticut Department of Veterans Affairs was the first in the nation to adopt a policy in conjunction with new federal law to provide burial rights for our Hmong and Laotian SGU veterans at the State Veterans Cemetery in Middletown. I hope that Connecticut will continue that leadership by providing these Hmong and Laotian veterans with the recognition afforded other U.S. combat allies of eligibility for the Connecticut Vehicle Marker Plate, Operator / Identification Card or License, and the Connecticut Wartime Service Medal. People like Connecticut's own General Sar Fatusik, who some of you I think know, and his fellow Special Guerrilla Unit veterans, U.S. Vietnam veterans, and veteran service organizations across our state and nation have been advocating for these types of recognitions for years for our SGU veterans. Our Vietnam veterans fought a protracted, unconventional war that unfortunately became mired in a political morass. When they came home, they had to fight a second war. They suffered insults and attacks, but they persevered, not for themselves as individuals, but for their brothers and sisters.
Not me.
In order to secure recognition and benefits they deserve in service to our nation. This bill would extend a level of support and recognition to those Hmong Laotian veterans who fought alongside of our U.S. Vietnam veterans. The Connecticut Department of Veterans Affairs has for many years stood with our Vietnam veterans in supporting greater federal and state recognition of our Hmong and Laotian veterans, also known as the Irregular Forces, who served who supported the U.S. military in Vietnam. As I did state in my opening remarks here, Connecticut currently does permit burial of Hmong Laotian veterans in our state veterans cemetery under federal law, and attached as Appendix A to my testimony, which is the policy to be adopted on June 27th, 2019. So therefore, there is not a need necessary to include such a provision of recognition in Section 4 of the bill as proposed. The other issue is that we must comply with federal laws of recognition related to burial in the state cemetery. So to the extent there is any distinction between burial eligibility at the state level versus the federal level, we must default the federal level of eligibility, which does recognize the Hmong through a particular process because we do receive federal funding for our cemetery. With regard to Senate Bill 118, an act concerning the definition of veteran. This bill would expand the category of persons eligible for state-based veterans benefits to those who received an OTH and other than honorable discharge from the U.S. Armed Services. Unlike the current qualifying conditions of TBI, PTSD, and MST, which are determined at the state level, this expansion of eligibility will rely on official administrative decision from the United States Department of Veterans Affairs that a veteran with an other than honorable characterization of discharge is considered to have served honorably for certain VA purposes. Be candid, there is disagreement within the Connecticut veterans community and beyond regarding this legislation, which I certainly appreciate, particularly as on my military side, a judge advocate in the Army Reserve. As there is concerns of the possibility that in some cases, the VA determination that services are appropriate for certain OTH veterans that determination may be issued, notwithstanding the fact that the veteran's underlying conduct may, to some person's view, have warranted that OTH characterization. And I'm sure you'll hear more articulate explanations of those concerns as well as support for this bill from other speakers. That said, to the extent additional persons are deemed eligible for such state-based benefits, there could be, and there would likely be a fiscal impact, both at the state and municipal level, because there are also tax exemptions that municipalities provide. However, that number is difficult to measure, as I do not know and was not able to obtain from the federal VA the exact number of individuals that fall within this category. It is likely fairly limited, as back in 2017 and 2018, the department estimated that there were less than 2,000 living OTH veterans, and this group would be a subset of that group. With regard to House Bill 6481, an act concerning registration marker plates for veterans and members of the armed forces who served in certain or in periods of war. This legislation proposes to require the Department of Motor Vehicles to issue marker plates recognizing specific wars or conflicts in which certain veterans served. These marker plates would be in addition to the current Connecticut Veterans Marker Plate and 12 other specialized veteran vehicle plates, such as the Military Order of the Purple Heart, 82nd Airborne, Marine Corps League, etc., many of which are affiliated with associations, rather than being directly issued pursuant to state statute. As drafted, the proposed periods of war or conflicts recognized are those that are identified in 38 USC 101, the United States Code, which are World War II, Korean War, the Vietnam War, and the Persian Gulf War, and quote, other periods beginning on the date of a future declaration of war by Congress and ending on the date prescribed or proclamation by the resolution of Congress. Just to be clear, the reference to 38 USC 101 does not necessarily cover certain distinct periods of wartime for which campaign or expeditionary medals or ribbons were issued to service members, such as war in Iraq and Afghanistan the war in Iraq in the 1990s, then again in 2003, and the ongoing war in Afghanistan. Also, Connecticut General Statute 27103A recognizes several distinct periods of conflict or war, separate in addition to federal law, for purposes of determining eligibility for Connecticut wartime service-based benefits. I only highlight this just to ensure that the committee in the end is clear on what periods of war you would be asking the DMV to affirmatively recognize with a distinct marker plate, and to be cautious with cross-references to other statutes, particularly at the federal level, without digging down into those particular statutes. I will not go through the details of this, but I did include in my testimony examples of specific marker plates in 5 Northeast states, including Massachusetts, Rhode Island, New Hampshire, New York, and Vermont, each of which take a slightly different approach. Some have specific plates, others have general plates with a specific campaign ribbon affixed to that plate. But I would defer really to the Department of Motor Vehicles as to the logistical capability and the cost of expanding the number of available plates, as there is no cost directly to the Department of Veterans Affairs to expand the number of plates available. I will end with the explanation of how we determine eligibility for plates as well as driver's licenses with veterans markers. Currently, it's Department of Motor Vehicles that determines eligibility for the standard veteran marker plate and a few other state statutorily issued plates. The others are determined by the organizations such as Military Order of the Purple Heart, 82nd Airborne Division, etc. This differs from the process for veteran designation on the Connecticut driver's license or non-driver's license identification card. Those determinations are made by the Department of Veterans Affairs through the Office of Advocacy and Assistance. And then we interface with a digital portal at the DMV and issue that eligibility indicator or indicia that then the DMV can look at when an individual comes in to renew their driver's license or to obtain a driver's license or ID. To make the entire process more efficient between the two agencies, the DVA could serve as a certifier of eligibility both for driver's licenses and IDs, as well as potentially to determine eligibility for more particularized veterans marker plates, or for all of those that are officially issued by the state. What I mean is non-association plates. However, we would need to, and I would encourage at least an opportunity to, or the creation of an electronic interface where the DVA would have access to certain portals within the DMV system so that we could provide a paperless process of eligibility certification for any expansion of the recognition of veterans plates. I thank you for your time, your service to our veterans, and I'm happy to respond to any questions regarding this testimony or other concepts under consideration by the committee.
Thank you. Thank you, Commissioner. And we always appreciate your succinct way of giving us a lot of information very quickly. I did have a chance to look at your written testimony as well, and you go into a lot more detail on some of the stuff. So again, we appreciate your work to help us sort through this. So are there any questions from the committee for the Commissioner? Any questions? Senator Berthel, you have the floor.
Good morning. Thank you, Mr. Chair. Commissioner, always a pleasure to see you, and thank you for your testimony this morning. I do have one question regarding the license plate explanation, and thank you for all the detail on that and your concerns about making sure that we, if we should move this forward, that we do it correctly. I think that's of utmost important to make sure we're recognizing the right periods of time and not creating more work than we should. You started out your testimony with respect to this and saying that some of the existing plates have some of the revenue, maybe my words, but I think what you said was some of the revenue for the existing plates goes to support certain veterans agencies. And I'm wondering if there should be any additional thought given for the bill regarding looking to see if we should be doing that with any of these veteran type plates to support those agencies that so graciously and importantly assist veterans in their time after their service. So I wonder if you have a comment on that or if you think that's a terrible idea or a great idea. Thank you.
Thank you, Senator. Great to see you as well. And I really appreciate that question because I just want to clarify my testimony. Revenue does not go to those organizations such as Military Order of the Purple Heart, 82nd Airborne, the Korean War Veterans Association. What it is in existing DMV statute and regulations, there are opportunities for organizations to establish plates, specialized plates for their membership. If they have a certain threshold, I believe it is, or at least was, approximately 400 petitioning members who sign up to do it. The DMV will issue the plate, but those organizations are the certifying authority for eligibility. So if I was a combat wounded veteran, and I wanted a Military Order of the Purple Heart plate, some of you have probably seen them as you've driven around Connecticut, I contact the president or commandant of that organization, provide my documentation to that commandant or commander. They issue an eligibility certificate, usually in hard copy, and that is then brought to the DMV with the application for that particular plate. There is not a transfer of funds or funding to those associations. And also, you do have to be a member of those organizations in order to receive that plate. So if I'm not a member of the Military Order of the Purple Heart, but I was combat wounded, I'm not eligible for that plate unless I'm a member of the associations. That is distinct from statutorily issued or authorized plates for which you do not have to be an organizational member. I hope that addresses it.
I'm sorry, I interrupted you, Commissioner. Mr. Chair, if I may just follow up. Thank you, Commissioner. I appreciate
Please.
the clarification. And I think I kind of knew some of that, and I appreciate you providing that very fine clarification on that, because I think that that it's important that we all understand that as we move forward with this. I think this is a great idea to recognize our veterans for the theaters that they served in and the wartime that they were in. But I'm appreciative of the clarification regarding how those organizations are responsible for those other plates, and that it's not necessarily a revenue share with DMD. So thank you for the clarification, and thank you, Mr. Chairman.
Thank you, Senator. And I would just point out to the committee, although the DMV is not testifying in person, they did submit written testimony that's in our file on this as well, where they have some suggestions. So thank you, Senator. Other questions for the commissioner? Other questions for the commissioner? All right, well, Commissioner, we appreciate your time. And if we don't have a hearing next week, I'm going to feel a little emptiness in my heart that we don't start the day with you. So we appreciate it as always.
Representative, thank you very much. And to all the committee members, appreciate your time. And if there are follow-on questions, please, yourself or your staff members, reach out to my office. More than happy to assist in any way with clarification on both my testimony as well as any technical questions related to some of the legislation. Thank you.
Thank you, Commissioner. Next on the schedule, we have Senator Kelly. I don't know if he has joined us.
Excuse me, he has not joined us yet.
Okay, we'll keep an eye out and then slide him in. Then we'll go to number 3, Christopher Arnold from the Department of Defense. Welcome to the committee.
Good morning, Representative Boyd, Senator Cabrera, esteemed members of the committee. It is wonderful to see you again. The Department of Defense is grateful for the opportunity to support the policies reflected in House Bill 6483, which addresses the need to alleviate the challenges military-connected students face during constant moves during their K-12 education years. My name is Christopher Arnold. I am the Northeast Region Liaison at the DoD State Liaison Office, operating under the direction of the Undersecretary of Defense for Personnel and Readiness. I am also a combat veteran. With each move, military service members face numerous challenges as they bring their spouses and children to resettle into new communities and attend new schools. Mobile military students face issues such as gaps and overlaps in curriculum, different graduation requirements, course placement disruption, and many other hurdles when changing schools. Besides the academic issues, these students also face social and emotional challenges of relocation, such as leaving supportive social networks and activities to start new again. As with most statewide K-12 education policies that set a baseline level of support, specific guidelines not prescribed within the language of state policy are left up to districts for local implementation. Section 1 of this legislation addresses this challenge by allowing military orders to be accepted as proof of residency for the purpose of enrollment in a public school by children of members of the armed forces. With nearly 3,200 active duty military school-aged children attending school in Connecticut, your state is in a unique position to have a positive effect on the educational experiences of military children and families by enacting the policies set forth in House Bill 6483. The intent of this policy is not to offer an advantage or priority over other students, but simply to provide military families access to educational programs and courses at the same time as their in-state peers. No new online systems are required, and there is added benefit to school districts by reducing the discrepancy between projected and actual student enrollment numbers for staffing purposes. Connecticut House Bill 6483 will also help schools aggregate and centralize knowledge so that critical information is easily accessible to students, families, faculty, and staff by creating a statewide Purple Star Schools program. Purple Star schools are military-friendly schools that have demonstrated a major commitment to students and families connected to our nation's military. Designated schools have met specific state-designated requirements to support the unique situations facing military students and their families. As our military members and their families move from state to state, providing for a smooth educational transition for their children is key to eliminating one of the largest concerns that parents face. Purple Star is, of course, a bottom-up initiative that has no central governing body. Thus, DoD has identified as a best practice that states utilize their discretion to design and administer a statewide version of the program to ensure efficaciousness through research-driven components such as those set forth in House Bill 6483. Purple Star also creates an opportunity for military-impacted schools to bridge the gap between educators and evaluators of K-12 metrics used in basing decisions by the military services. In closing, Let me say that we are grateful to Senator Cabrera, Representative Boyd, and Representative Conley of Groton, who represents our subbase, for helping shepherd this important piece of legislation through the Veterans Affairs Committee. On behalf of the Department of Defense, we thank you for considering House Bill 6483 and respectfully pray for your favorable report of this bill. As always, as Northeast Region Liaison, I stand ready to assist and answer whatever questions you may have. Thank you.
Thank you, Mr. Arnold. And I'll just say you've been a wealth of resources thus far, and we appreciate that. Can you just speak very quickly to certain matrix that particularly the Department of Defense and the federal government uses when awarding federal money to state? Normally the state, puts up a certain amount of money that unlocks federal money for the military, but often there's checklists and there's a weighted scale, if you will, that money is looked at, that if the state has certain things. Do these two bills play into that weighted scale and would help or hurt, depending on our action, what potentially we could become eligible for some federal money?
Sure, and that's a fantastic question. And some of you may be familiar with the Department of the Air Force basing evaluations and the 2019 criteria. The 2021 criteria actually are in the process of being finalized. And I have a meeting this Friday with the Air Force to discuss all of my states. But they do evaluate military spouse licensure and then K through 12 education. And one of the metrics that they look at is military student transition. So having family-friendly policies like advanced enrollment, which allows military children to access registration and enrollment to a school district at the same time that it's open to the general population, and removing that proof of residency requirement, or at least easing it, is one of the factors that they evaluate in basing decisions and mission alternatives.
Thank you. I appreciate that clarification. Questions for Mr. Arnold? Questions for Mr. Arnold? All right, hearing none. Thank you for your time and sending in testimony. We appreciate it.
Thank you. Have a great day.
You too. Next, I believe, is Emily Trudeau. Emily, the floor is yours.
Thank you, and hello.
Welcome.
As I stated last time I testified, I am a veteran of Operation Iraqi Freedom, and I am a past chair of the Veteran and Military Affairs section of the Connecticut Bar Association. I oppose this bill. I oppose this bill for many reasons. In my unfortunately lengthy written testimony, which I do hope you read, I've given many examples of individuals who would be allowed benefits under this bill, and I do hope you read them carefully. They are all real-world examples of which I have personal knowledge. I'd like to dedicate my oral time, however, to 3 points, as in reading other written testimonies, there's a lot that I don't think is being presented completely clearly or accurately. First, many of the testimonies focus on the more sympathetic cases of mental health issues rather than the more common VA cases of various physical injuries such as back pain or tinnitus. I think just about every former sailor, regardless of their discharge characterization, has tinnitus, which is ear ringing, somewhere in their VA profile. Now, Connecticut has already passed a statute to help individuals with qualifying conditions, those being PTSD, TBI, and military sexual trauma. In fact, this statute is consistent with DoD policy, which is to provide an honorable discharge upgrade whenever there is a nexus between misconduct and an undiagnosed mental health issue. Separation authorities are given clear guidance on how to handle these cases at the front end, as are upgrade boards who are instructed to take an expansive and permissive approach to these claims. The claims being denied by the discharge upgrade boards are claims in which the diagnosis was found unconnected to the misconduct. Second, the procedures at issue are not clearly represented right now. Honorable for VA purposes is not intended to supplant a DoD discharge characterization. In fact, under federal law, that is explicitly not the substitution. This bill does not complement DoD policy, it explicitly undermines it. I think it's helpful for this committee to think of the VA process not as a disciplinary review or an appellate authority over the discharge process, but as a very elaborate, very well-funded, and very expansive workers' compensation system. In fact, unlike the civilian world, any injury sustained, including an injury sustained on leave, as one of my examples shows, could be considered, in fact, would be considered service-connected. A pre-existing condition could be found service-aggravated. The VA is simply looking to see if there was a shred of meritorious service, or as the boilerplate language calls it, honest and faithful service, such as to warrant health care. They are instructed to take a permissive approach to these evaluations because we want people to get health care. This country has a health care problem. The VA recognizes that and wants to take an expansive view, especially in mental health care issues. But that is not meant to cancel out the OTH determination for other gratuitous benefits. It is explicit in federal law. That point is, again, explicit. Third, I want to talk a little bit about the administrative separation process. Again, I was a judge advocate for 7 years. I've been on both sides of this process. I've been a defense counsel and I've been a recorder, and actually all three sides of the process. I've also been a staff judge advocate advising on how to refer these matters. The system right now is being represented as an arbitrary and capricious system subject to the whims of tyrannical COs who look to be some sort of hybrid of Captain Queeg and Colonel Jessup. This is simply not true. To get an OTH, the command must convene an administrative separation board. That is not required, but to get an OTH, it is, I should say, that is not required to separate a service member necessarily, and we'll talk about that in a moment, but to get an OTH, a board is required. At this board, 3 board members must determine that, number one, the alleged basis for separation was met. Number two, separation is warranted in light of the totality of circumstances, including a full review of the service member's record. And three, that an OTH is warranted, again, in light of the totality of circumstances. An individual could find, a board could find that the basis for separation was met, but separation wasn't warranted. Similarly, a board could find that separation was warranted, but an OTH was not warranted. An OTH basically means that the negative aspects of that service member's contribution to the armed forces outweighed any good they may have done. Now, at these boards, the service member is represented by counsel. The service member has a right to review in advance of that board any materials that are going to be used as part of that separation board. And they have a right to present evidence in their defense. They have a right to challenge evidence being used against them. It is a very thorough and very fair process. In short, they have much more due process than any civilian employee. Can you imagine a civilian job in which a supervisor or HR would be told, we know you want to fire this person, but we need to give them a lawyer, we need to give them a hearing, and 3 other employees have to agree with you? That's simply not present in any other system. So again, when I read these statements talking about the unfairness of the administrative separation process, it simply does not jive with anything that I've seen in 7 years on active duty.
So, Mr. Trudeau, I took a look at your testimony. You did send in lengthy testimony with lots of different examples, which we do appreciate. You know, people often think that written testimony is not looked at. In many cases, it's what we digest with after public hearings. Would you mind yielding for some questions?
Absolutely. Excuse me, absolutely not.
Yep. Representative Linehan.
Hi, thank you so much. Hello, Ms. Trudeau. How are you today?
I'm well, thank you, ma'am.
Good, thank you for being here. Your testimony, just as the chairman said, it is lengthy. However, it's enlightening. We've seen this bill multiple times, and never before have I, or not at least in my memory, have I seen so many different scenarios as you have pointed out. And I appreciate you mentioning the fact that we did pass legislation to help those who had discharges other than honorable, due to military sexual trauma, traumatic brain injury, and PTSD. And so I just want to I hate to do this because your testimony is so thorough and really terrific and helpful. But just to kind of put it together into one lump sentence, it's almost like you feel that by doing this, it's actually taking away from the benefit that we did in that earlier bill, because you recognize that the other than honorable discharge was due to circumstances their control, but that this one is actually based on poor behavior that should be considered dishonorable. Is that correct?
That is absolutely correct, ma'am. And it has not only the kind of more societal interest of we don't want to reward bad behavior, but it also takes away a valuable tool, which I believe my husband from the commander's perspective is going to speak more on in a moment. But what I can say, and I mentioned this in my written testimony, is as a judge advocate, my advice to the commanders that I was advising was very frequently, because again, there is a very finite list of reasons a person can be separated. We cannot just separate someone for being bad at their job like you could in the civilian world. In that situation, the way that would be handled is we would try to shuffle them around, find a different assignment, and just let them, complete that first enlistment, and probably recommend that they not be allowed to re-enlist. But as long as they complete that first enlistment, that's an honorable discharge. No questions about it. If they complete their contract, it is an honorable discharge. So we would really try. So we can't just separate someone for not being a good employee. There has to be something beyond that. And those some things beyond that are also violations of the UCMJ, which could potentially be sent to a court-martial instead of an admin board. And a court-martial is considered a federal criminal conviction. A special court-martial is considered analogous to a misdemeanor conviction. A general court-martial is considered analogous to a felony court-martial. And so
can you give examples of what those two things might be?
So for example, I'm trying to think of cases from my own experience.
I'm sorry to put you on the spot.
Larceny, depending on the amount that was stolen, would go to a special court-martial. We're not going to send someone to a general court-martial for stealing an Xbox from the Navy Exchange. We're just not. A general court-martial, sexual assault, serious assault, assault in the first degree type situations, running a drug ring, things like that are going to be your general court-martials. And those, at a general court-martial, you can give a bad conduct or a dishonorable discharge. That is the only way to give a bad conduct or a dishonorable discharge. A dishonorable discharge has to be at a general court-martial, the felony level. There's also a third punitive discharge, which was not mentioned at all in this proposed bill, which was another issue I had, and that is the dismissal. An officer can only get a dismissal. Now, it is statutorily and severity-wise analogous to a dishonorable discharge, but for an officer, it's called a dismissal, not a dishonorable. And so again, to get back to my point, my advice to commanders when we're talking about minor misconduct that definitely doesn't belong at a general court-martial, but may or may not and probably doesn't belong at a special court-martial is, how strongly do you feel about a criminal conviction and jail time for this? Or do you just want them out of your unit? And is taking away some of their veterans benefits enough of a deterrent message to the rest of the unit? And invariably, the commanders, unless they really feel strongly about jail time or a lasting criminal conviction, would go the separation board. And the reason for that is the command has to pay for the court-martial. And the command has to wait for the court-martial to be completed, which means they're taking this file, sending it over to the Region Legal Service Office, letting the prosecutors at the Region Legal Service Office wait for their docket to clear, wait for their turn in line. There's also a full discovery process. There may or may not be pretrial motions practice. The court-martial process takes a long time to get through. And I can say from personal experience as a defense attorney in the military, there are ways to make that even more painful for the command. For example, any witnesses that the defense wants to call, including experts, are paid for by the command. And actually, they changed that policy during my time in, where it's not the individual warfighting command because they have smaller budgets. It goes to the region. The region now has, but it's still coming out of a military budget. It's still coming out of the convening authority's budget. And so what I would do as a defense counsel, one of the things you're allowed to do in a military court-martial system is present what's called a good military character defense. It's basically saying, this person couldn't possibly have committed this misconduct because look at what a good service member they are. It's not necessarily a successful defense. In fact, in my experience, it's not a successful defense, but it is still a recognized defense under the military rules of procedure and the military rules of evidence. So what I would do is tell my client, give me a list of everybody you've ever served with who might possibly have something good to say about you. And I want that list in the order of who is the geographically furthest from you right now. In other words, the person who is going to be the most expensive to fly out here to testify in your defense. And then I'm going to submit my witness list and say, guess what, convening authority, you have to pay for all of these witnesses. And that's a great way to make commanders really think twice about, does this really belong at a court-martial? Is this really worth the pain of a court-martial? And if not, we're going to deal with it at an administrative separation board, and we're going to use the OTH instead of the criminal conviction as both the punishment for that member and the deterrent effect to ensure good order and discipline within the unit.
So basically, again, because you are such a wealth of information, and I appreciate this so much. But basically, again, to just sum it up for maybe people who are watching this, who aren't aware of all of this, is essentially there are a million steps and hoops to jump through. So if somebody is determined to be other than honorable, there is a reason behind that. And there were steps to make sure that it was the right decision, or if they were court-martialed, it's a reason, steps to ensure it was the right decision. And ultimately, then you believe that this would go against those decisions. If we then said, okay, so you were found to be guilty in a court-martial, or you were discharged other than honorably, but we're still going to give you all those benefits that the good, hardworking people in your unit are enjoying as well. Is that summing it up well?
Yes, and I want to just backtrack very briefly to talk about something that's being missed in the discussion of the ADSEP process. There's something called notice requirement, which is if an individual has less than 6 years of service, the command can separate them without a board, but the worst the command can do in that situation is a general under honorable circumstances. To give the OTH, it has to go to a board. Now, if an individual has more than 6 years of service, they can do what's called a board waiver, which would also frequently happen, where the command says, look, I really don't want to deal with the hassle of an admin board. What they did wasn't really that bad, but we need them out. If they're willing to take either an honorable or a general and waive their board, we're just going to give them that and make it real easy, real quick. And I'll give an example of cases that we would do that often with. Individuals who failed drug tests. Obviously, an individual who's using drugs while on active duty cannot be retained. It creates a safety issue to the unit. We can't have that. But we would look at some of these individuals and say, you know what? If they hadn't failed their drug test, we never would have known, because otherwise they've been doing a really great job. And we're looking at their service record going, you know what? They've done some good work for us. Just being on drugs is not a crime in the civilian world. It's really only a military offense. And so we're not going to punish them beyond kicking them out. And we're going to give them an honorable discharge. And we're going to let them, try to have a, good luck, Godspeed in your civilian life. And so we would often, even if we were separating people, we would offer them an honorable discharge. If when we looked at their record, we said, you know what you did wasn't really that bad, but it is something that we can't tolerate in the armed forces, but we don't want to stigmatize you. So we're going to give you an honorable discharge as long as you waive your board. And frequently that's what would happen. And some of these individuals actually, after being kicked out of the military, would turn around the very next day, go apply for a job at a civilian contractor company who was actually doing work for our unit, and come back a week later as a civilian contractor, which was kind of funny. But again, it was like, this wasn't a bad person. We didn't want to punish them, but we can't have people using drugs in the military.
Right, and put the unit at risk. That makes complete sense. Thank you so very much for your testimony and your time. I know that you have sincerely educated and enlightened me prior than any other testimony in the past few years. So I just want to thank you very, very much for that.
Thank you.
Thank you, Representative. Any other questions? Any other questions? Okay, Mr. Darrow, thank you for your time. We appreciate it.
Right, very quickly, if I may, in closing, I am more than happy to help this committee come up with policies and procedures to help veterans. I am more than happy to help educate this committee. I certainly believe that what we should be doing is providing resources to push people into the discharge upgrade process and make sure that they are aware of those rights. Because if an individual gets their discharge upgraded, that's a whole different story. Because is there a possibility that someone might fall through the cracks? Absolutely. But that is what the discharge upgrade process is for. And there are very, very lengthy and detailed regulations that they are following. And I have some excellent contacts at the Army JAG School, who's the institution tasked with training attorneys on how to handle these procedures. And so what I will do is I will give Ms. Byrne my contact information. I'm not going to put it out on a public hearing, obviously, but I will be happy to provide her my contact information. And if you want any resources or any points of contact within the DoD, including military mental health care providers, including people training judge advocates, I am happy to help provide that, because I do want to make sure
that'll be great. Thank you very much. We appreciate your testimony. We're going to now jump to Senator Kevin Kelly, who we skipped earlier,
Great.
and then James Trudeau. You're going to follow there. So, and Representative Linehan, you are unmuted. So, without further ado, Minority Leader Kelly, the floor is yours.
Thank you very much, Chairman Boyd, also Chairman Cabrera, ranking members Ciccarella and Vale, as well as all members of the committee. Thank you very much for the opportunity this morning to testify in favor of Senate Bill 917. We all share the goal of making Connecticut more affordable for all our residents. We share the goal of passing policies which improve everyone's quality of life. And we also very much appreciate the selfless service of our veterans, and we strive to do all we can to help veterans in need. Senate Bill 917 steers our state towards each of these goals. It would exclude all veteran federal pension benefits from income when determining eligibility for public assistance programs. The bill states that to the extent permissible by federal law, the Commissioner of Social Services shall disregard any federal pension benefits granted to a veteran or their surviving spouse when determining income eligibility for the state's Medicare Savings Program, medical assistance, and energy assistance programs. Passing Senate Bill 917 will help vulnerable veterans and their families in getting the vital assistance they need. This policy builds upon the progress we made 2 years ago when we passed 3 laws with bipartisan intention of expanding ability of veterans to access certain state services and provide assistance when they return to civilian life. Those laws established job training programs to help veterans with skills needed to obtain jobs in advanced manufacturing and other related positions, expanding eligibility for veterans to receive certain state benefits, and provided greater property tax relief. Here in Connecticut, we are a role model in the nation for recognizing that those who have served in the armed forces deserve opportunity and relief. We will always remain committed to helping our veterans from our greatest generation to the latest generation. We will always be grateful for their service. Thank you for your cooperation of this new relief measure, Senate Bill 917. Let's make Connecticut more affordable for our veterans and help them to better access these vital state services. Thank you once again. Any questions?
Thank you, Senator Kelly, and I wholeheartedly agree with your testimony. Is there any questions for the senator? Questions for the senator? Okay. Again, we appreciate your time, and hopefully we get some movement on this. Thank you, sir.
Thank you very much. Take care.
Next is going to be James Trudeau, followed by David Rosenthal. So, Mr. Trudeau, the floor is yours, sir. Welcome.
Thank you, and good morning, Senator Representative Boyd and members of the committee. Thank you for inviting me today. And personal capacity, I am a 16-year veteran of the United States Navy and presently serve in the Navy Reserve as the officer in cargo afloat rig team, Attachment Alpha, headquartered up in Manchester, New Hampshire. I wanted to take a moment. I believe my wife did a great job of outlining the procedural issues around these discharges and the process we go through as commanders. As a commander, we carry out a great responsibility, which is, of course, the nature of the role. Responsibility to the chain of command for the performance of a unit, to our peers for counsel and mutual support, and to our sailors for maintaining a culture and providing them a mission worth risking their lives. Well, good leadership, and all of this is underpinned by a need to maintain good order and discipline within a unit. Good leadership always tries to work with a sailor and keep them on the good and righteous path of service. It's not always easy. It's one of the jobs, and in fact, in many ways, the joys of the role of a officer or a senior enlisted in the military is working with a sailor who comes to you troubled and helping them turn their lives around. It is it's a rare and beautiful opportunity to be given. And while good leadership always tries to work with those sailors, we cannot allow repeated or severe misconduct to go without a response. Doing so threatens the unit, it reduces morale, and risks failure in a time of war. And this bill is going to make that job ever so much harder. We have to have a response for misconduct such as theft or repeated or unauthorized absence or repeated incidences of smaller failures that grow into a problem that we cannot address through the initial punishment proceedings. It's never something we approach lightly. And what this bill will do is, as currently written, nullify the punishment that we can be through those administrative proceedings. This is a disciplinary tool. This would allow service members discharged for misconduct to return home and claim the rights of their peers who had served honorably. Bad paper discharges, as Commissioner Sadi stated, are a mere fraction of all discharges, something around 2%. This is keeping with my experience. Over 16 years, I've been party to 3 administrative proceedings. 2 of those, including the case of the drug-using sailor who returned to the unit a week later as a contractor, resulted in people who were discharged and still maintained an honorable reputation of their service. We are fortunate in this state to have an excellent Department of Veterans Affairs. If the legislature wishes to support veterans seeking a discharge upgrade, I would suggest that we are better off providing Commissioner Sadi with resources to assist them in pursuing records correction through the process. This is fair to the member, it's fair to the service, and it supports the commander in his role of maintaining discipline within a unit. Thank you for your time today. I'm happy to answer any questions from the committee.
Thank you. Thank you, sir, for your testimony and spending time with us today and for the service of both you and your wife. Questions, Representative Linehan.
Thank you very much, Mr. Chair. Hello, Mr. Trudeau. Thank you very much for being here. And my dog apparently thanks you as well, if you can hear him barking. Thank you for your service and thank you for your testimony to both you and your wife. I really don't have any questions. I just want to thank you both for being so thorough in your testimony and really giving us great things to think about. So I just wanted to just take a minute to thank you, and that's all.
Thank you, Representative Linehan, and thank you and the committee for your service to our state.
Absolutely.
Thank you both. Any other questions? Any other questions? Okay, very good. Thank you for your time. Next is, I don't believe Mr. Rosenthal is present, so we will skip him. And then next we have Nicholas Montini, I hope I pronounced that correctly, from the Veteran Transparency and Accountability Fund. The floor is yours, sir. Oh, you're muted, sir. There you go. Welcome to the VA committee.
Hey, thanks very much. Thanks for having me. Good morning, Senator Cabrera, Senator Boyd, Senator Ciccarella, Representative Vale. honored members of the Connecticut Legislative Committee on Veterans Affairs, Commissioner Said, and distinguished membership of the Board of Trustees, Connecticut Department of Veterans Affairs. My name is Nicholas Montini. I'm a Fairfield, Connecticut resident and the United States Air Force Persian Gulf War veteran, honorably discharged. I'm also a father, a husband, and uncle, a veteran peer support mentor, and chief impact officer of the Veteran Transparency and Accountability Fund. We are a veteran support and grant service organization dedicated to sustainably and augmentation of highly functioning veteran recovery programs across the Northeast. As a veteran consumer and beneficiary of both the VHA and Connecticut Department of Veterans Affairs benefits, I testified before you this morning in urging strong support for the passage of Senate Bill number 918, an act concerning the definition of veteran under the Connecticut statute. I'm glad and honored today to have the opportunity to speak in favor of the bill's current form and content, which at this point within the rich history Connecticut has shared with her patriots cannot be understated as it pertains to the present and future livelihood, overall development, and recognition of those Connecticut's towns and cities, of those residents who have taken the shared constitutional oath to defend the nation and state upon successful enlistment into the armed forces of the United States. These oaths, I might add, were taken before and after 9/11, oaths that were taken many, many times over by Connecticut sons and daughters over the last 19 years on two major battlefronts. As of 2020, over 2.7 million US service members have deployed to active war zones in Iraq and Afghanistan, with Connecticut representing roughly 1% of that population. Many studies within and outside the Department of Defense point to the wars in Iraq and Afghanistan as having been more difficult on service members and their families than have past wars. With more frequent and multiple deployments the norm, I ask this committee to seriously consider the stressors associated with living and working in prolonged, strenuous, and mission-critical environments, as most of the 2.7 million I have mentioned have experienced in defending Connecticut from abroad. I would also respectfully ask this committee to assess their personal definition of the word character as it relates to any one of these 2.7 million patriots who are without question in 2021, all mission accomplished. However, the interpretation and meaning of one's military discharge for state purposes has become open to debate. And I believe Section 1, subsection A of 27-103 of the Connecticut General Statutes, if they were to be left unrepealed, there would be no wider opportunity in the future to redress the collective understanding of the meaning of veteran in Connecticut. I believe most importantly of the bill's ability to affect the future and life chances of many, many benefit-seeking ex-service members across Connecticut. Character of service does matter. There is no question here. Other than honorable military services discharges certainly warrant a benefit application service record review for any type of benefit approval in Connecticut. I would like to add as well that other than honorable discharges, as mentioned before by Ms. Trudeau, remain lesser in distinction, lesser in negative distinction due to one's conduct on or off duty. However, and I feel it important to distinguish between the negative discharges, that other than honorable discharges under the Uniform Code of Military Justice have and remain to be largely administrative in nature. To my point, the lesser two discharge statuses from other than honorable discharges, both the bad conduct and dishonorable discharges, does require the accused service member to sit for either a summary, special, or general courts-martial as referenced by Attorney Trudeau. These two discharges, the lesser of the other than honorable discharges, are designed to penalize upon separation. I do believe a firm understanding of both the bad and dishonorable discharges and their processes can serve as guideposts to help this body in ultimately determining the legal definition of human character and its ability to distinguish itself as being deserving after service. Ultimately, the pride within the bill and the spirit of it all is an inclusionary framework. By expanding the definition of veteran, we can now include veterans whose service has been reviewed and determined to be honorable by the Department of Veterans Affairs, the Federal Department of Veterans Affairs. And also, the benefit will be in helping to remove the stigma of less than honorable discharge that is due to behavior that a result of unaddressed trauma, mental illness, or the effects of even discrimination. Thanks very much.
Thank you, Mr. Montini. I appreciate your time and your testimony. Are there any questions from the committee? Any questions from the committee? Okay, hearing none again, thank you for, oh, I'm sorry, at the last moment, Representative Linehan.
Thank you very much, Mr. Chair. I appreciate the indulgence. Hello there. Thank you very much for your testimony, sir. I just have a question. So we heard from the Trudeaus earlier, and they're talking about the things that may result in this other than honorable discharge. And a couple of years ago, we did pass a bill that would make it so anyone that was discharged other than honorably regarding due to PTSD, military sexual trauma, and traumatic brain injury would be able to get their benefits. So, but you're talking about now, you mentioned some things like discrimination, and so can you explain to me how someone might come about being discharged other than honorably and due to discrimination or mental health? Because look, I don't know if you're aware of the work that I do, but mental health is of extreme importance to me. So I'm wondering how mental health wouldn't fall under the PTSD, TBI, or MST. I just want to get at exactly what we'll be doing here, because when we heard from the Trudeaus, it was like we'd be talking about kind of the illegal behavior, the worst of the worst. How can you explain to me how it won't be that?
Well, the worst of the worst is clearly reserved for the bad conduct discharge and dishonorable discharge. That's why they're the lowest of the low, and they're meant to penalize. When I say discrimination, it's really a broad sense that the United States military, as well as civilian society, has many different attitudes, and there's certain biases associated with what one does, where one comes from, those types of things. I think we'd be deluded to be thinking that the military is separate and distinct and more viable not to see discrimination within it. But I have seen cases, direct service cases, where discharges were forced upon folks either in retribution or with respect to other matters and identifiable characteristics. The DoD obviously has done everything they can to instill a sense of fairness throughout the troops, throughout all commands and branches of services. They continue to work on that today. But with the idea that there are many different angles of being a service member and translating all those experiences to their home states, it's important to understand that folks who have been discriminated against within the military for whatever reason, they're out there too, and they do make up numbers within the population that I had mentioned earlier.
So I see I don't know if you still are, forgive me for not knowing, but the project leader of the Veterans Recovery Project of Connecticut. Is that correct?
At one point in time, yeah, that was an AmeriCorps program. It's pretty cool.
That is cool.
Yeah, we went to battle with homelessness in Connecticut for veterans.
That's what I wanted to talk about. So
I'm wearing my AmeriCorps pin. I'm an alumnus, so thanks for noticing that.
Thank you so much for your work. But I'm wondering, so are these things connected? The inability to, maybe get these VA benefits for what you would say would be, mental health reasons or the other reasons that you listed. Is that connected to veteran homelessness?
Absolutely. I think they go hand in hand. For one to be dismissed from the military, fall on hard times, and eventually find themselves drifting within and out homelessness, of course, they're going to go to the VA. There are homeless programs there, namely the Supportive Services for Veterans and Families program for the homeless. If you don't qualify for that, you're really kind of in a situation where nobody's going to notice you for what you've done or what possibilities that you can have without being homeless. Sure, these benefits will help a lot.
Great. And then does the VA have inpatient and outpatient drug services for addicts?
As far as inpatient goes, yes, I know there are programs where I don't quite know, but there are day programs for substance abuse disorders. throughout Connecticut, both Newington and West Haven. I know there are programs as well at Rocky Hill, which are great, and upcoming programs at Rocky Hill that have been doing so well with folks.
And just to reiterate, if someone receives an other than honorable discharge due to drug abuse, and they have not gone through the process of getting a doctor's notice saying that it was due to PTSD or military sexual trauma, then they do not have access to those veteran services, correct?
That's correct. However, mentioned earlier was the movement to really point folks in the discharge upgrade area. A process unto itself. Most folks who are seeking benefits, if they are denied via their discharge status, will seek to upgrade it through legal means.
And that discharge upgrade process, help me to understand, that is on the federal level.
Absolutely.
Not on the state level. So if we have homeless and drug veterans who need help, is there any mechanism by which we can, on the state level, help them to get whatever they need on the federal level, seek through those legal means, even if they, do they get help from us if they're already if they have an OTH?
Right. Well, here's the good thing. There are resources out there. Certain pro bono law firm programs, Connecticut being with the Connecticut Veterans Legal Center, one of the most prominent in attacking the discharge upgrade program. Many veterans cut through the Aurora Community Care Center in seeking that legal relief. Now, the marriage between mental health and legal can't be disputed. Obviously, one who is mentally struggling, if they're not certain legal order, there's going to be probably future effects of that. So that's been studied greatly. I understand the work with the Connecticut Veterans Legal Center has been stellar to many hundreds of veterans, not only in seeking discharge upgrade, but drawing benefits that are deserved.
Yeah, thank you very much for that information. I'll just end with this, that when I hear you talking about this, knowing what I know about depression and suicidal ideation, if someone is severely depressed, it could be difficult waking up that day and brushing your teeth, let alone going to find legal help to get them a discharge upgrade. So you've given us a great deal to think about, and I very much appreciate your time and your testimony and your work.
Thank you.
Thank you.
Thank you, Representative Linehan. Representative Ferrero, you have the floor.
Thank you, Mr. Chair. And thank you, sir, for your testimony. Nick, I just have an observation, I guess, and a question.
Yes, sir.
It almost seems that in the conflicting testimonies that we've heard today regarding this bill and the other than honorable discharge, that there is question today as to whether or not the other than honorable discharge is actually a needed category. Would you characterize that?
Sure. A needed category, I think, speaks for itself. When I hear the words other than honorable, it brings a lot to mind, but it does kind of capture the middle base between the truth of honorableness and the negativity of being a bad conduct troop. That middle area would be a playground for folks in trying to determine what would constitute deserving benefits under those circumstances. But again, I just have to point to the 2.7 million folks who deployed multiple times. We've never had within our populace so many battle-tested troops. What manifests through that is well knowledge as well. Again, the TBI, the mental illness, the post-traumatic stress disorder. 1 out of 4 returning troops at this point are being looked at as having suffering in some way or another, not necessarily PTSD. But all those other elements we hear about, like military sexual trauma, TBI, PTSD, and the other afflictions one can be service connected to. This bill means a lot to me. Obviously, my direct service with a lot of folks who are marginalized Their testimony to me personally is up front in my mind when I say, please pass this bill or see to its fruition. This affects many, many thousands of folks here in Connecticut. And, with that number in mind, I hope, compassion can be realized or perhaps materialized in policy decisions you folks make. But we're civilians here. And with that said, as civilians, I think we should take upon ourselves those who have served or have attempted to serve deserve our respect and consideration. Thanks.
I thank you for your passion in this issue. And as I said, I had an observation and that was it. And I had a question attached with that. And my question would be, I've heard from you that that these folks, even they have served and that they are deserving of respect. I've heard that there's some question regarding this middle ground between bad and dishonorable and honorable. But what I can't get my head around in listening to your testimony is what then would be considered valid other than honorable discharge in your mind?
What would be a valid reason to accept an other than honorable discharge?
Yeah, what would be a valid reason to separate a military personnel, member of the military, with an other than honorable discharge?
Sure.
Because I'm not seeing that in your testimony. I don't see it.
Well, as mentioned, there are crimes that absolutely need to be addressed. However, they may not rise to the level of felony. With your other than honorable discharge, you're looking at the varied misdemeanors. There could be violence involved. That could be an indication of, the severity of the other than honorable discharge as well. What I'm saying is somebody with an other than honorable discharge seeks benefits. It's apparent that they're going to have their service record at least looked at first in order to make an approval, as opposed to somebody with an honorable discharge where they go ahead and automatically plug into benefits. I think it's the least we can do in Connecticut, especially after the last 19 years of warfare and the many thousands of men and women who have served and defended Connecticut abroad.
Thank you, sir.
Today, call Connecticut home.
Thank you, Nick, for your testimony. And thank you, Mr. Chair.
Thank you, Representative. Any other questions? Any other questions? All right. Thank you, Mr. Montini. We appreciate your time spent with the committee today. Thank you. Next is going to be Sarah Ryan, followed by Cindy Johnson. Ms. Ryan, the floor is yours. Welcome to the VA Committee.
Thank you. And thank you for this opportunity. I'm a practicing veterans attorney and professor of practice at Wesleyan University. At Wesleyan, I teach a course in legal advocacy for disabled veterans. Of course, the views I'm about to express are mine and not Wesleyan's, but I want to talk about the robustness of the VA recharacterization process and why Connecticut should adopt VA determinations. The military, as we all know on this call, is the nation's largest employer. Its personnel procedures and adjudication procedures are among the most complex, transparent, and fair of any large employer. My Wesleyan students read sections of the Marine Corps Separation Manual, a many hundreds page document, and the Uniform Code of Military Justice. We review court-martial documents, performance evaluations, and other personnel paperwork. And I teach my students that the military system is largely transparent, fair, and just. But even the military makes mistakes. The military wrongly characterizes a small percentage of the many discharged service members each year. And the Department of Defense, as we've discussed, recognizes this through the discharge upgrade process. But I've represented DU clients, and those processes take years and a lot of energy. Veterans Affairs has created a different system for determining which service merits access to benefits, and that is the determination that Connecticut is considering today. As an attorney, I've handled VA benefits cases, and I can attest that the process is rigorous. The VA is guided by federal statutes and regulations that bar recharacterization for dishonorable conduct. If a service member becomes a conscientious objector on the eve of deployment to Kabul, they will not win their VA recharacterization. If they had a drug addiction prior to service, hid it from the recruiter and brought it into the military, they will not win their VA recharacterization. The laws governing the VA process eliminate these cases, and these laws are sufficiently strong to protect the public and to honor military service. This semester, my students are reading the files of a service member that won his VA case. They're reading more than 1,000 pages of personnel and medical records. They realize that he won a good conduct medal, as most of my clients have, for years of honorable service. And then he succumbed to mental illness from combat traumas, the likes of war movies. This client won his VA case because he met the statutory and regulatory criteria, and his 1,000-page file showed that on balance, he had served faithfully, and he should have been diagnosed with some mental illness in service and was not. The process worked because it was rigorous, legal, and fair. With this law, Connecticut has an opportunity to make its public benefits program more fair and inclusive. As opponents of this bill rightly argue, the state should not open military veterans benefits to anyone who served for any amount of time with any performance. That would dishonor veterans, but that's not what this bill does. This bill adopts a designation awarded by Veterans Affairs, guided by federal law and regulation, and a rigorous internal VA process that recognizes the few among many who truly served faithfully and honorably, but received the wrong discharge. Thank you.
Thank you, Professor Ryan. Questions from the committee? Questions from the committee? Okay, seeing none, thank you for your time. We appreciate it. Next is going to be Cindy Johnson, followed by Thomas Burke. And there you are. The floor is yours, ma'am.
Hi, good morning. Thank you so much for having me today and allowing me to speak. I am here today. My name is Cindy Johnson. I'm the Deputy Director of Connecticut Veterans Legal Center, also known as CVLC. And I'm the chair of the Veterans Military Affairs section of the Connecticut Bar. So today I'm wearing two hats. I'm also a resident of Hamden. I'm here today on behalf of both the CVLC and the CBA to speak in favor of Senate Bill 918. We've been hearing a lot about it. This being the third public hearing and the second that's directly discussing the definition of veterans and access to benefits, I'm going to assume I can skip some of the basics. My written testimony provides a lot of detail around the VA process, and I'm happy to answer any questions this committee has. As mentioned in the written testimony, CVLC is a medical legal partnership. We're partnered with the Connecticut Department of Veterans Affairs as well as the federal VA. We work really closely. We primarily work with veterans who are referred for assistance by their clinicians, and this is how the topic first came up for us. At the time, going back 10 years, the VA recharacterization process was little known and rarely used. From 2010 to 2012, only 6 were filed nationally. In 2011, CVLC got their first case where this VA process that we're all learning about a lot today was first used in Connecticut for us. A homeless Navy veteran, the VA brought him to our attention because his discharge status, because of that status, they were unable to provide the services to him that they knew he needed. The regulations that Sarah just referred to barred him from VA services. So we reviewed the law, filed a brief, and it was determined that his 2 infractions, after 16 years of service, did not meet the willful and persistent misconduct definition in 3.12, 38 CFR 3.12. That's the really guiding regulation here. So without changing his DD 214, his access to the VA did change, not his access to Connecticut benefits. That's what we're going to talk about today. This first recharacterization was followed by a few years of CVLC trying to find the fastest, most efficient way to get veterans who meet the recharacterization criteria defined in the regulations into and through this new process that we feel like was really important. As the rate of other than honorable discharges has increased steadily over the years, so has the use and the widespread knowledge of this VA recharacterization process. We've learned a lot about this process along the way. CVLC has filed over 100 since that first one 10 years ago. but the success is far from guaranteed. I reviewed our history and found that over the years, 140 Connecticut residents have come to CBLC for assistance and some guidance through this process. We reviewed their military records and out of the gate found that 30% of those clearly didn't meet the criteria required by the VA. And of the remaining that we did file for recharacterization for, 75% of those we were successful. So the raw numbers basically is about 50% of the people that came to CBLC asking for assistance through this VA process, we were able to achieve that goal. The rest of them didn't really meet the criteria required by the VA in order to have served honorably. We have helped, most recently, several post 9/11 veterans as well through this process. One, an Army Pathfinder and an Airborne Ranger who signed up for service the week after 9/11. Also an amazing Marine. Both of these stories are on our website if you'd like to read about them. But their service was honest, faithful, meritorious, and served the benefit of this nation up until they didn't stick the landing. You know, the ending wasn't perfect. Based on Yale's estimates back in 2018, I've met only less than 10% of the veterans in Connecticut who have this other than honorable status, who may or may not need access to the VA. The Veterans and Military Affairs section and CBLC work with an amazing amount of attorneys, all working just like Sarah, who will provide pro bono services for veterans trying to go through this process, access to the VA benefits and or the discharge upgrade process. Each of the veterans we've served has served this nation with honor. You just have to dig deeper into their service than their DD-214 to know that. And that's what this process does. It digs deeper. So for me, the question is, should their service be defined only by how it ended? Or should the Connecticut definition take into account the entire service? Going back to what the VA uses in their determination. Was their service honorable, honest, faithful, meritorious, and a benefit to this nation? Quite often it was. And I think the people that meet that criteria go through this extreme process with the VA. Yes, there's a discharge upgrade process available to them as well. And some take advantage of it, but some don't because there are limited resources. And that is not a magic bullet. So I wanted to thank you for the opportunity to speak to you today about this bill that we are very passionate about at CBLC and
Thank you.
CBA.
Thank you. And we'll take a good look at your written testimony as well. We appreciate that and the work that your group does. Questions from the committee? Questions from the committee? Okay, seeing none, again, thank you for your time. Next is going to be Thomas Burke, followed by Catherine Steele. Mr. Burke, Reverend Burke, welcome.
Good morning. I am very appreciative of you all taking this time. This committee has done such wonderful work for veterans in the state, and so I'm glad to be here to put a personal face to this Senate Bill 918. I am a former infantry Marine. Some of you are familiar with my story, and I apologize. I will go a little into it. I was an infantry Marine who deployed to Iraq and Afghanistan with 1st Battalion, 3rd Marines. I spent 9 months in Iraq, and then I spent 9 months in Afghanistan. In my last month of Afghanistan, I watched a bunch of little children that I grew a relationship with because of the language skills that the Marine Corps sent me to learn for Pashto. And these were members of the community and local nationals who helped us in our mission to combat the Taliban. And they ended up bringing me an explosive, and my unit was tasked with cleaning up and disposing of the bodies afterwards. I am somebody who is born and raised right here in Connecticut. And when I experienced that trauma, I dealt with it by using hash that I received from our local Afghan police in order to self-medicate. Because of that self-medication, I ended up receiving an other than honorable discharge from the Marine Corps. I had multiple diagnoses of PTSD from Navy doctors. And in response to that, this is not an arbitrary process, there was a codified law in 2009 that would prevent veterans like me who received diagnoses of PTSD or TBI. Currently, I have CVLC counsel, and it's taken quite a while in order to receive that are working on my case, finding these codified law policies were not followed. And so when I returned home here to Connecticut, I had no benefits. I had really no future. And fortunately, and really why this is so personal and difficult is because I'm terrified of what would happen if the VA did not give me a characterization of service decision as honorable. They made that decision automatically. I was fortunate to have all of my medical documents very, very well documented by my corpsman, by the head physician of our base care facility. And so everything, the explosions that I had gone through, the traumatic brain injuries I experienced, the multiple traumatic events that I witnessed were all well documented. And so when the VA received my paperwork, they automatically saw that this was somebody who deserves care. And now I did not receive care or benefits from the VA because of a shred of honorable service. It was because my disabilities were service connected. And so what that allowed me to do was it allowed me to receive substance abuse rehabilitation services from the West Haven VA, which allowed me to access educational benefits, which allowed me to get a bachelor's degree right here in Sacred Heart University, and then do so well in my undergrad that I was accepted to Yale Divinity School, and I graduated with my master's in divinity in 2018. And no small part of that was because of this committee and the hard work that they have done to boost benefits for veterans here in the state. I will try and wrap this up, and I apologize. I am somebody, last year, I just got veteran plates on my car. I'm a firefighter here in town, and I can't tell you how proud I am finally after a decade of getting out of serving in combat in Iraq and Afghanistan, finally feeling like I'm recognized by my home as a veteran. And again, I want to I'm trying to make this personal and a little less about policy so I can give you a face for who this represents. But I am a pastor of a church in Weston, Connecticut. I am somebody with an Ivy League education, and there is no way I would have received any, and I now am in an opportunity to serve my state, to serve my community. And that's because you all and people on the federal level continue to support vulnerable veterans and give them the help that they deserve. And so I really want to thank this committee for all their hard work, because I'm very afraid of where I would be without it.
Thank you, Minister. You're right. We do talk about policy a lot at a very high level, so it is actually refreshing to see a face and a story behind it. And I appreciate your service. And as a Sacred Heart alum myself, we appreciate you joining the committee. Questions for Minister Burke? Questions? Okay, hearing none. Again, thank you for your time and giving us your story. We very much appreciate it. Take care. Catherine Steele is next. I do not believe she is present, so we will move to Nicole Paquette from the Connecticut Funeral Directors Association, followed by Steve Kennedy. Ms. Paquette, the floor is yours. Nicole?
Good morning.
Good morning. The floor is yours. Welcome to the committee.
Thank you, Senator Cabrera, Representative Boyd.
Ah, there you are.
Yes.
Very good.
Okay, let's try again. Good morning again, Senator Cabrera, Representative Boyd, Senator Ciccarella, Representative Vale, and the distinguished members of the Veterans Affairs Committee. My name is Nicole Paquette. I'm a licensed funeral director and the legislative co-chair of the Connecticut Funeral Directors Association, CFDA, which represents 220 funeral homes. Thank you for raising House Bill 6480, an act concerning the funeral expenses of certain veterans. CFDA submits this testimony in support of the bill. The bill endeavors to clarify terminology related to funeral expenses for certain veterans who may be covered by the sum paid by the state. As funeral directors, we prepare funeral service contracts. As such, we recommend further useful clarification to the bill language and have submitted an amendment attached to this testimony to better define the meaning of funeral expenses in lines 44 to 46. Funeral expenses include not only funeral services, as stated in line 45. Funeral expenses also include other funeral merchandise and cash advance items as well. It is the sum total of the funeral services, funeral merchandise, and cash advance items that constitute the funeral expenses. Also, in lines 45 to 46, the cost of burial or cremation are generic and too broad of terms. And the cost of publication of an obituary is only one example of what is primarily a cash advance item. Besides an obituary, funeral expenses includes other cash advance items. These are amounts owed to third parties and are included as a courtesy on the funeral expenses bill to a purchaser. Thank you for proposing House Bill 6480, which seeks to specify and clarify funeral expenses for certain veterans to receive a sum paid by the state. The Connecticut Funeral Directors Association voices our support, particularly with the inclusion of our clarifying language to address the vague terms regarding funeral expenses. CFDA thanks you for what you do and for your consideration. I make myself available to questions or any comments.
Thank you, Ms. Paquette. I think you hit the nail on the head. We opened this up specifically to address obituaries, and as we were going through the legislative language, we realized that that statute was extremely old and antiquated and unclear. And so there were some things we looked at and that we're considering. So your suggestions are very timely because we kind of unearthed another problem when looking at trying to include obituaries within the sum that the state could award as well. So again, we appreciate your testimony. Any questions from the committee? Any questions from the committee? What is the going rate for an obituary these days?
I'm in the, we're finding in our area, and I'm in Cheshire right now. We also have a funeral home in Waterbury and Naugatuck. We're finding an average is about $500 for an average publication of an obituary. But again, there's price discrepancies in the state. But that seems to be there's several hundreds of dollars. Often when we meet with families, they're quite surprised at the cost of the publication of an obituary.
Yeah. And we had heard anecdotally that, in increasing numbers, folks are skipping the obituary piece because of the cost. And in many cases, there's not a lot of other forms other than social media to notify the public that death has occurred. So I appreciate your giving some perspective. Questions from the committee? Questions from the committee? All right, very good. Thank you for your time. Take care. Next and last on our list, which is completely by accident, I'm told by the clerk that we're not purposely putting Mr. Kennedy as our closing act every single public hearing. It just happens to work out that way. So with that, we welcome back to the committee, Steve Kennedy. Sir, the floor is yours.
Great. Thank you, Representative. Senator Cabrera, Representative Boyd, Senator Ciccarella, Representative Vale, and distinguished members of the Committee on Veterans Affairs. My name is Steve Kennedy. I'm an Iraq veteran who served as an infantryman with the 82nd Airborne Division, and I'm the Connecticut team leader of Iraq and Afghanistan Veterans of America. I would like to express our support for SB 918. This bill addresses an oversight in Public Act 18-47, which some have referenced earlier, for which we were the main proponents. Now, this act passed unanimously in 2018 with the support of the state VFW, American Legion, and Vietnam Veterans of America, and was actively co-sponsored by almost every veteran in the General Assembly. This tremendous show of support for our veterans was in recognition of the inadequacy of military discharge characterizations to be the sole determinant of who should be eligible for state veterans benefits. A 2017 U.S. Government Accountability Office report showed that 62% of veterans with less than honorable discharges, like Reverend Burke, who we heard from, had been diagnosed with a mental health condition at the time of their discharge. Veterans with less than honorable discharges die by suicide at twice the rate of their honorably discharged peers, are more likely to experience homelessness and substance abuse, and have a greater difficulty securing employment, all of which severely disrupts their ability to reintegrate after they leave the service. And for veterans suffering from mental health conditions, the loss of access to veterans benefits can mean they're ineligible for treatment for the very conditions that led to their discharges. And it's true that it is essential for commanders to have the flexibility to administer discharges to maintain readiness. It's that very necessity for readiness over fairness to individuals that requires a robust system to determine benefits eligibility on the back end. Because the discharge system prioritizes the unit over individual considerations, the follow-on review should favor the veteran. And especially in the light of the increased numbers of less than honorable discharges given over the last 2 decades, the military's review system currently is not up to the task, and litigation is still ongoing to get the review boards to even follow their own stated policies in regard to mental health conditions. It's partly for this reason that the VA began conducting characterization of discharge reviews on its own. So at the state level, when we crafted Public Act 18-47, we approached the issue of expanding eligibility with the knowledge of the administrative burden that any extensive review of veterans records would place on the State Department of Veterans Affairs. And for that reason, we chose a narrow set of qualifying conditions where we could comfortably presume a connection between a veteran's condition and discharge status, namely PTSD, TBI, and MST. However, as the proponents of SB 918 have pointed out to us, the federal VA does have a process for reviewing veterans' records for benefits purposes, designed with the knowledge that the military's discharge upgrade process takes longer than many veterans can wait to receive these vital services. And in these cases where the VA has determined that a veteran's service is honorable for VA purposes, it's only natural that the state would recognize this determination as well. To do otherwise would run counter to the intent of Public Act 18-47. So certain conditions such as, say, depression or generalized anxiety were excluded from that legislation simply because the state didn't have the resources to make that more fact-intensive determination. But for those with the VA discharge characterization, that determination has already been made. So for veterans who've made it through this rigorous screening process, we're generally not talking about people who have serious misconduct. We're certainly not talking about people who didn't make it through training. We are often talking about people who were combat veterans, people who were sexually assaulted, and maybe, so under current law, maybe they're not diagnosed with PTSD, maybe it's depression, but the VA has made the determination that it was related to their discharge. I would further point out that excluding veterans with OTH discharges from these benefits is not only unjust, it's actually counterproductive. These are veterans who signed up for incredibly difficult jobs, suffered a trauma, and had a hard time dealing with it. Many of these veterans could have just as easily gotten an honorable discharge under other circumstances, say if they hadn't been deployed or if they'd gotten out of the military before their symptoms began to manifest. So we believe that you have an opportunity here to keep the promise that we make to our veterans and make them whole. This isn't a giveaway. These are people who have demonstrated call to service with valuable skills. We don't only owe them assistance, we stand to gain by restoring them and allowing them to be leaders here in our communities. We've already lost far too many of them to addiction, homelessness, despair for us to continue turning them away. And we can't accept that any of our returning veterans could take their lives while waiting for these vital services. So I, again, urge you to pass SB 918 and show all of Connecticut's veterans that we won't leave them behind. I would point out too, just there are several other bills that we do support that we'll put in written testimony on, but I'd be happy to take questions on any of those.
Thank you, Mr. Kennedy. Thank you for your service and your continued advocacy. There's kind of been a little bit of a running theme and a discussion that's been happening on this bill today, mainly around the upgrading of the discharge and that whole process. And some have said that that's the avenue that folks should go by. Others have said we shouldn't rely on it. What's your take on that process and that discussion we've had today?
I'm sorry, could you repeat that? My sound just cut off for a second.
Yeah, my students tell me that all the time when I ask them questions. There was a lot of discussion today about the discharge upgrade process that currently exists, and some have argued that this really needs to take place through that. Others have said it's not a reliable process and doesn't really get to the heart of the issue that this bill is looking at. What's your take on that, and what direction should we go on? Should we rely on it? Should we not? I'm curious in your thoughts.
So I would say that, we, again, in 2018, this committee and the entire General Assembly made the decision, with the support of all of our veterans groups, that we can't solely rely on that discharge upgrade process. That's why we, allowed for qualifying conditions in certain cases. As far as the discharge upgrade process goes, I would point out that it's something that takes several years, and as I said, we're talking about veterans who are more likely to have mental health conditions. It's incredibly difficult to go through this very rigorous process, wait years and years for this to happen when you are dealing with, if you're dealing with depression, dealing with PTSD, something like that. And again, that's why the VA set up this system. I would think that what this bill is looking to do is actually like much less of a leap than what we did in 2018. I think this is a relatively conservative change when we're talking about people who have gone through this pretty rigorous VA determination process.
Thank you. And, as with anything, the fiscal note that potentially would be attached to this is something that's going to have to be put into consideration. Through your analysis or study, do you have any sense of how many veterans potentially would be impacted by this?
So we don't have an exact number, but as Commissioner Sadi noted, their study, along with Yale, several years ago, estimated there were only about 2,000 veterans with less than honorable discharges in this, with other than honorable discharges in the state. With 62% of less than honorably discharged veterans having a mental health condition, at most you could make that estimate about 1,200 impacted veterans, but that number is likely far lower since few veterans actually receive an honorable characterization of service from the VA. And again, as far as how many veterans would be newly eligible for benefits, there are many who would be covered by PA 18-47 already. So we would expect very little fiscal impact. And then I would remind the committee that when we did work on this in 2018, where it was likely a larger expansion, there was no fiscal impact. There was no fiscal note attached to that bill.
Thank you. Representative Buckabee.
Thank you, Mr. Chair, and thank you for your testimony, sir. Thank you for your service. I just had to jump in on this a little bit because the mental health piece, I think, across the board up here in this building tends to be ignored on a regular basis and tends to be pushed aside for other things. I think Representative Boyd covered one of my questions I had with the number of people and with the fiscal note, but I think the fiscal note, wherever it may be, is well worth the dollars invested to it. I'd like a little more from you, if you wouldn't mind, too, about the number of people we're talking about this serving across the state. I think it's an important thing that we do, but I think that impact is critical for maybe you to expand on a little bit as well.
Sure. So like I said, as far as who would be newly eligible under this bill, I can only make an informed guess, but because we covered a fair number of the veterans in the state with NOTH with the previous bill, and because again, I think you heard from Cindy Johnson before, not that many veterans go through, even attempt the process of getting a VA recharacterization, and then even fewer actually receive it. So I think we're talking, if I had to guess, I would say we're talking about dozens of veterans out of a population of about 150,000 in the state. So it's a drop in the bucket as far as the fiscal impact is concerned. But for those individual veterans, the impact is huge for them personally, for their families, for their communities. Something that's usually not captured, I think, as you alluded to, in some of the fiscal analysis is the positive impact that actually bringing these veterans, kind of building them back up, allowing them to be active members of our communities also has a positive fiscal impact. I mean, we have veterans, if they don't qualify for healthcare and they are dealing with, say a mental health condition, they show up at a hospital, we're still all paying for that. The fact that they're not able to work is something that harms our economy. I think that, so I'd say that the cost is really marginal, but then the potential benefit on the individual and community level is actually very large.
Excellent, thank you. That's a great answer to it. And again, couldn't agree more. We need to do more. My only other question I had for you is we've talked about this in other areas too, outside of the Veterans Committee. We've talked about the stigma of mental health and the people reaching out to ask for help. Is this going to be a concern too? Because there is sometimes what would be considered a tough guy mentality. You don't ask for help. Is there an additional way to reach out to assure that our veterans receive that care and mental health?
I think that that is a difficult problem. It's something that, honestly, I've dealt with myself. I've been really, in my role with IAV, I have been very public about my own struggles with PTSD and depression, suicidality, things like that. And it was for the first few years that I was at, was extremely difficult to actually talk about that or discuss it with anybody. I think that there are many different avenues that we kind of need to come at it from. What we try to do is basically community building. So just bringing veterans together. I think even when you're not talking about it openly, just being around people who have shared experiences is helpful. But I think something that bills like this do that also helps in this area is to recognize the service of more veterans. Right now, somebody who has a mental health condition and received an other than honorable discharge for it, there's an incredible amount of shame that attaches to that. I think makes it even less likely for someone to reach out and get support. So the more that we officially recognize that service as a state, I think the more likely we have people actually reaching out and getting the support that they need.
I completely agree. I have a dear friend who received 3 Purple Hearts and has dealt with his own PTSD and it's helped him tremendously to talk about it. So thank you again for your testimony. Your written testimony is extensive. I've enjoyed reading that as well, and I appreciate the time. Thank you so much for your testimony, and thank you, Mr. Chair.
Thank you.
Thank you, Representative. Any other questions for Mr. Kennedy? Any other questions for Mr. Kennedy? Okay, seeing none, as always, thank you. And we promise we'll get you earlier in the agenda in the future. So thank you.
That's good. Thank you.
We did skip over Catherine Steele earlier in the agenda. So I see she's logged on now. So Ms. Steele, the floor is yours, ma'am.
Hi, good morning. I'm just a supporter of veterans in town who need services, and just am so interested in being a support. And I know with COVID and social distancing that a lot of my friends are starting to get their vaccines and getting back. So I guess it's going to be the new normal. But in the meantime, it just feels like we haven't done enough. So basically, my question is kind of at a personal level: how can I be a better support? What can I do to reach out to local veterans? What kind of avenues to help create? Because I understand all of the issues. 3 of my brothers served. I was one of 9 kids. I had 7 brothers. 3 of my brothers served, and one was in the Army, and the other 2 were in the 2 were in the Army. 1 was in the Marines. So just helping to understand what I can do as a local volunteer.
Thank you for your testimony coming before the committee. I often will tell people the best people to contact is your local municipal veterans representative, because they have the best sense of what the situation locally and what the needs are in your particular town. And that is a good way to start to support the veterans community, because they're often tied in with other service organizations and things like that. So Representative Vail.
Thank you, Mr. Chairman, and as per usual, you stole my thought. I just wanted to mention to her, Catherine, what town or city are you from?
I'm in East Lyme, and I'm on the phone with Brian Burridge at least a couple of times a week. He's our East Lyme town representative. So, and he and I have been working, he calls me his tag team partner. We work a lot on behalf of a veteran who was an Iwo Jima, so WW2 veteran who's currently 96 years old. So been trying to be a support to that, and then attend, of course, the coffee houses are all virtual. So I'm in East Lyme, to answer your question.
Yes, and because I represent the towns of Stafford and Summers, and they both have really great programs. And Summers in particular has a volunteer one. They have an office right in the town hall. And what they do, there's a lot of programs that are available to veterans in the state of Connecticut, but they're not. The biggest problem is letting them know what's out there and what's available. So that would be important. We happen to have amazing volunteers in my district that go above and beyond to make sure that they do that, and the town supports them in that. So that would be my recommendation. Get in with them, maybe talk to some of the other communities, other communities around you and how they do it. But the most important thing is letting veterans know and getting the word out to all the programs that actually are available to them, because there are quite a few. And I think a lot of people I know, I've become much more aware of it since I've had this position, that I could have helped my brother, who could have certainly used some help in a lot of those regards. And so there's tons of programs available out there. So that would be my best suggestion. Get in with the East Lyme, and then find out what other areas are doing, and just try to help veterans with find out more about the program. That would be my suggestion.
Okay, I appreciate that. Thank you.
Thank you, Representative. Other questions from the committee? Okay, hearing none. Thank you for your time, ma'am, and spending some part of your day with us.
Thank you.
Madam Clerk, is there anybody else that has joined us or would like to testify?
There is not.
All right. Seeing that, we will adjourn today's public hearing. I appreciate